Good day, everyone. Welcome to Helps YouTube live channel. My name's Eric Olsen, Executive Director of Helps. Helps is a national law firm that represents seniors and disabled persons who owe debt they can't afford to pay. And we educate seniors on how they can maintain their financial independence. I'd like to welcome you to our YouTube live channel today. Um, and Good to have you here. If you have any questions, you can put them in the chat feature. I'll try to answer them there. Also have things to talk about today. Um, and so we'll get started. A person contacted us from New York, and they say, I'm 62 years of age, and I applied recently for Social Security. They've not worked for over a year now, and I have an American Express bill of almost $40,000. I've been trying to pay off with personal savings. I can't sustain all of my bills. Um, can I stop paying American Express? What is the procedure? Um, Says I'm expecting $2,500 in Social Security. Uh, they have a mortgage payment. They want to know they owe American Express almost $40,000. Well, okay. Which brings us to the most important message Helps has for seniors, and that is that your Social Security, your pension, your disability, your VA benefits, your forms of retirement are protected under federal and state laws. It's safe. It can't be taken from you. It's available for your needs, for your food, for your medicine, for your housing. Now, if you can certainly pay your bills, that's great. But you don't need to take your retirement funds, especially those retirement funds you've got a set amount. When they're gone, they're gone. Use those to pay old debt. Then eventually that amount that you save for your old age is gone. And now you're just limited to your regular Social Security or regular pension. This extra money you have. So this person, when he says he's been taking his savings to pay the American Express bill, probably isn't a good idea. Okay? Now, what's going to happen if he doesn't pay the American Express bill or any other debt? Well, the creditors can call. They can send demand letters. But if you understand that your income is protected, your Social Security, your pension, your disability, then what can they do? Well, they can harass you, and what Helps is a national law firm that represents seniors and disabled persons who owe debt under a federal law called the Fair Debt Collection Practices Act. Now, that law provides that if you're represented by an attorney, debt collectors have to leave you alone. They have to communicate with the attorney, not you. And so what happens with Helps is we send what's called a cease and desist letter out to the collectors you don't want to pay. And that letter tells them that you're represented by an attorney and they're no longer to call you or send you demand letters anymore. They have to communicate with us. Okay? And so when they call us, you're in our system. We explain that you're on Social Security, you can't afford to pay the debt, and not to call you anymore. And they'll stop. Okay? Now, the Fair Debt Collection Practices Act applies towards debt collectors, not original creditors. Although some states, there's 7 or 8 states that apply to original creditors. But the fact of the matter is, we send a cease and desist letter out to anyone that you owe money to, even if it is an original creditor, and it's not their practice to continue to call you. Now, if it's an original creditor, they may still send you a bill, and if you're enrolled in Helps, we tell you if you don't want to get that bill, you can either throw it in the garbage or you can do a change of address with the debt creditor to have the bill sent to your name, care of Helps, with our address. But we want you to understand that you don't need to worry about the old debt. The whole purpose of Helps is that if you have a question or concern, or you're worried about your financial situation as far as the debts are concerned, or any other thing regarding your financial situation, you give us a call and we'll talk to you. We'll assure you why you're going to be okay, why they're not going to be able to take your assets. We're going to tell you how your bank account is protected. There's a federal law put into effect in 2012 that instructs banks that they're to automatically protect twice the amount of federal benefits deposited into a checking account or a bank account from from a garnishment. And if you were sued and they tried to garnish your bank account, twice the amount of your Social Security for in your bank account from garnishment. Most people I talk to, they'll tell me, well, Eric, I don't get more than, I never have more than twice the amount of my Social Security in my bank account. I tell you, well, you don't have anything to worry about. So if you have any questions for us during this YouTube live session, put them in the chat feature and I'll try to answer them. I'm probably going to need to end a little bit early today. We have about 40 minutes because I've got another meeting I have to be at that I can't make an exception for. But we have these YouTube live sessions Monday through Thursday at the same time. Okay? And you can look at them later if you want to. And you can look at ones from days before too. Okay? But yeah, get your questions. We don't want to work. We don't want you to worry. So federal and state, what do you mean? Okay, when I say your income is protected by federal and state laws, it depends. Most income is protected under federal laws, like Social Security is some people may have a pension that's not protected under ERISA, and if it's not protected under ERISA, it's protected under a state law. Okay, so you're not going to need to worry about someone taking your Social Security or your pension. It's safe, including your IRA, your 401k. Okay. Now, what do I know? Well, I've been an attorney now for 46 years, probably filed 30 or 40,000 bankruptcies before I started help. I've never, in those many years in practice dealing with debt collectors, I've never seen a senior ever lose their pension, okay, to garnishment. My sound is going in and out. Well, that may be you. I hope it's not everyone else, okay, because I don't want the sound to be going in and out. So this person contacted us from Mississippi. Says, I'm 66 years old and worked up until last year and received Social Security and my pension. I took out a loan from Net Credit about 3 years ago. Now, who's Net Credit? I think it's a high interest loan outfit. There's so many of these out there, different ones. I now receive. I'm now not able to make all the credit card payments with the income I now receive. I have contacted some of the credit card companies and some are working with me. However, Net Credit refuses and have been getting where I cannot afford to make the payments. How much does it cost for me to represent me and stop the collection calls? Okay. First off, help doesn't turn anyone away that needs our help. Maybe 1 out of 6, 1 out of 5, 1 out of 7 of our clients get our help for free. Our fees are based on your household income. Some people would pay $20 for 24 months, $10 for 24 months free thereafter. Some people would pay $30 for 24 months, $15 for 24 months free thereafter. The most a person would pay normally would be $40 for 24 months and then $20 for 24 months free thereafter. And the payment wouldn't begin until 30 to 60 days after you decide to enroll. So when people decide to enroll in help, they call us on the phone. We ask them some questions. We save the information. They may call us 2, 3, or 4 times. We invite them to look at our YouTube videos and look at our website. And when they finally decide, yeah, it helps is the thing for me, it's going to solve my problem, then we can enroll someone over the phone. And we keep you on the phone and we click a button and you're immediately sent an email that says welcome to helps. And we'd like to be on the phone when you get that email. And it's fairly long and it has our contact information. It gives instructions how to get us the collectors you want to hear from. All we need is their name, address, and account number. We don't need the balance you owe. Okay? And then normally within 24 to 48 hours, we're going to send out a cease and desist letter out to that debt collector or creditor, letting them know that we represent you to receive collector communication. So they leave you alone. And now in the meantime, if they were to call, you tell them to call us. And so when a person enrolls in helps, when we hang up, if you got a collector call, as soon as that call is done with helps, you give them our contact information, and if they called us, 5 minutes, 10 minutes later, you're going to be in our system as being our client. So we help our clients immediately as their attorney to stop collector harassment. That's our main mission, is to stop collector harassment. But our second mission is to educate you how you can maintain your financial independence. Uh, that's one reason why our help is ongoing. It's not just one time, because you know we may send out these letters, and that may stop the collectors from bothering you. But you may get another letter from a new debt collector. 3 months, 6 months, a year down the road, you might get sued. If you got sued, you're going to get us a copy of the lawsuit. We're going to send a letter to the attorney that sued you, let them know that your income is protected. It's Social Security, it's a pension. Remind them of the protected nature of your bank account. Uh, don't really need to do that because it's protected by your bank anyway. Then we're going to call you on the phone, explain why you don't need to worry about the lawsuit, why you're not going to need to go to court, and why you're going to be okay. Okay? So that's what helps does. I need to shut my phone down so that I don't get. There we go. Sorry about that. So Linda says, I joined Helps 2 weeks ago. I bank with Chase. I can no longer pay a credit card with them. I do have a checking account and a current car loan I'm keeping with Chase. Okay, that's fine. Okay, there's a federal rule that tells banks that they can't offset money from your bank account to pay a loan that you don't pay to them. Okay, unless you gave them permission to take the money out. So you should be able to keep the checking account, and shouldn't be a problem with you paying the car payment. Now the exception with that is going to be if you bank at a credit union. And if you've been listening to me at all, you're going to understand that credit union is a little bit different. I always tell people they have a different stationery store than banks. When you sign up with a credit union, whether you realize it or not, you gave them authority to take money out of your bank account to make a loan payment if you stop paying it. Now, they normally want to do that unless you're several months behind. It gives you time to change to a different bank. But what if you're buying a car from a credit union? So if you had a car loan with a credit union and then you had a credit card with a credit union, um, when you made the credit union car payment and the credit union and the credit card payment, you sign what's called a cross collateralization agreement with the credit union, which says that if you don't pay one debt and you have another debt with the credit union, like on a car loan, that car loan is also secured by that other debt. So for that reason, it's a little bit different with credit unions. You talk to us, we'll tell you what can be done. Okay? But that's not the case with banks. The only exception is Truist Bank. They seem to have subscribed to the same stationery store as credit unions. So we do have a little bit of a problem with Truist Bank, and we talk to people about that when that comes up. You can always change to a different bank if you're worried about it. No problem with that. Nothing wrong with that. Okay, the clerk's office sent me a notice they're going to garnish my wages from my bank. I would think they would know the laws. I hope my bank doesn't allow it. Okay, I don't know what clerk you got this from. So, uh, if the bank gets a writ of garnishment served on that, first someone would have to sue you, Mary, and have a judgment. Okay, and then they'd have to know where you bank. And if they file a writ of garnishment on your bank, the bank examines where your money came from. And your deposit into your bank account, there's a code. If it came from a check you deposited, or if it came from Social Security or a federal pension of some form, then there's a code on there. And the department in the bank that deals with garnishments, if they get a garnishment, they examine where you got your money from. And if you got money from a federal source like Social Security, they take that amount that you received, they times it times two, and automatically protect that amount. Okay? And now your bank manager probably doesn't understand that rule. I guarantee you the clerk behind the teller, behind the cubicle there at the bank, doesn't understand the rule. So if you ask your local bank, about that. To verify that, you're probably not going to get the correct information, but there's a department in the bank that understands that rule, and so your income's going to be protected. Now, if you had a savings account, that could be different because that's not the account to which your Social Security is deposited. Your Social Security is likely deposited into your checking account. So if you had money in a savings account and you were sued, we'd probably be telling you to get your money out of the savings account or just keep a very small amount in there because it could be subject to garnishment. Now, if you have money in your account or in another account that's not automatically protected, or if you have more than twice the amount in your bank account, but it came from a federal source like Social Security, it's still protected. It's just not protected automatically, which means if you had excess money in there, you'd have to file some paperwork with the court called a challenge of garnishment or claim exemption to get that money back. We help people do that when that happens. We give them the information that they can do that. But most times our clients don't need to worry about that because they never have more than twice the amount of their Social Security in their account at any one time. Okay. So this person contacts us from Oklahoma. I'm reaching out to you for urgent assistance regarding a debt collection case that has become overwhelming for me to handle. I receive only Social Security disability benefits each month, and I owe Citibank approximately, looks like a little bit under $2,000. Due to my inability to pay, the debt went into default. Recently, I received a letter stating that I must pay the amount in full by a certain date or face legal action. And additionally, I was informed that my wife's income would be considered when determining a repayment plan. My wife refused to include her income, and I fully support her decision. I was summoned to court on February this month. Okay. During my appearance, I spoke with a representative who informed me that the total amount had increased to approximately $4,000 due to attorney fees and costs. When I asked how much I could pay, I offered $10 a month, but my offer was rejected. The representative then instructed me to wait so that we could both meet with the presiding judge. The judge granted me 10 days to negotiate a payment arrangement with the opposing attorney and my own legal counsel. I'm required to return to court on March 3rd, 2025 to provide an update on the matter. Okay, so let's remember one thing. This person gets, their only income is Social Security disability. They don't have to pay one red cent. Twice the amount of their Social Security deposit in their bank account is protected automatically from garnishment, regardless of what other funds are in there. A judgment against them, which there is, they don't have to pay it. The judge had no business telling them that they needed to work out a settlement agreement with the creditor. Now, judges don't know everything. A lot of judges, they only have a limited experience in the law. They don't know debt collection laws or these kind of things. And so, no, they don't have to pay this. If they technically don't even have to go back to court. If they get it, what is the creditor going to do? They could try to garnish their bank account as long as it's less than twice the amount of their Social Security in that account, their Social Security disability. They can't take anything. So when this person contacts us, we're going to tell them you don't need to worry. We would send a letter to the attorney who sued them. We're going to let the attorney know, hey, their income is Social Security disability. They can't afford to pay you. Their money's protected. They're not going to go to court. Don't need to worry about it. Do we need to contact the judge? No. No, the attorney can tell them that on the other side, because the judge can't order the client to pay the money. Judge has no authority to do that. So they're not going to need to worry. But we hear this all the time. Okay. So what helps us here for is to educate seniors about their financial rights. And that's what we do. One of these days, I'm going to get a new headset. Maybe it won't be as choppy. I never thought I would see the day I could sift those credit card companies out of their money. Well, I don't know if it's tipping or not. It's just, most of our clients, they would like to be able to pay the debt, but they simply can't. When it's a matter of heat or food or medicine and paying the debt, we want you to choose heat, food, and medicine. That's why laws were passed to protect your income so that it could be used for your needs like heat, food, and medicine. Okay. So Zeke's asking me, I had 2 lawsuits from Citibank served to me. Help send letters to the attorneys. That's what we do. We send a letter to the attorneys that sued you. Let him know that your income's protected. I own my house free and clear. Please tell me what happens next with the default judgment in Florida. Okay. So states protect equities in homes in different sums. In some states, they protect the entire equity. Texas, for example, will protect all your equity in a home. Okay? I often told the story about Governor Conley. He was I'm old enough that I remember when John F. Kennedy was killed, and John Conley, or I think his name was the governor of Texas. He later filed bankruptcy, and I remember in high school or in junior high seeing a picture of John Conley's home, which was palatial on a couple acres, worth over $1 million, and that was back in the 60s, okay? And that was a huge amount of money for a house. And he filed bankruptcy. He was able to keep the home. And I thought, my goodness, he filed bankruptcy and kept that home. So Florida is one of those states which, in almost every case, protects all the equity in your home. Okay? So, the judgment can become a lien on the home, but if you go to sell the home, there's paperwork you can file in Florida that releases the lien, and if you sell it within 6 months, then the lien's gone, and you can sell it and keep all the money from the proceeds from the home. Now, if you don't sell within 6 months, you can redo that paperwork and get another 6 months. So you're not going to lose. You're not going to have an issue with your home. And now, if you live in another state, you're not going to lose your home for various reasons. We talk about that. Okay? Okay. So this person contacted us from California. Hello, I need help with taxes, back taxes. So I'm going to assume that they're income taxes. Okay, what are we going to tell them? Well, first we're going to tell them if you owe the state income taxes, you don't need to pay them. The state can't take your Social Security or your pension. A state tax collector is prohibited from garnishing your Social Security or your pension, just like another creditor would be. Now, what about can the state take money out of your bank account? Twice the amount of your federal funds are protected automatically from a judgment creditor like a credit card, also from a state tax collector. Okay? Now, if you owe the IRS, it is possible the IRS, under certain rare situations, to do a set-off of 15% of your Social Security. I don't see IRS going after a person's pensions, although they legally could do it, but I don't see them doing it. Now, why would I know? Well, I've been an attorney for 46 years, filed 40,000 bankruptcies, and I've been with helps since 2012, 13 years now. We don't see the IRS trying to take a person's pension. Now, on rare occasions, they will send a letter saying they intend to offset 15% of your Social Security to pay a past due tax. But if your income is modest or lower, you can often get on what's called currently not collectible status with the IRS. We have emails that explain how to do that, and sometimes you can do it over the phone, especially if you're poverty level or near poverty level. It's pretty easy to do that. You can call them on the phone, wait for 2 hours for them to pick it up. If they fire a bunch of IRS employees, we may be working 3 hours, just a joke here. But when you get through to them and you can explain your situation, they can put you on currently not collectible status. Okay? You don't have to pay it. So, yeah, we talk to seniors about their taxes and answer these questions. See, our main mission is to protect you from collector harassment, but our second mission is to educate seniors how they can maintain their financial independence. Okay? So I'm going to skip down to something here. A person had a comment on our last YouTube live session, and I'll read what he says. Okay. Eric, why use helps if the debtor themselves can just change their phone number and file a template cease and desist letter with certified mail and return receipt, especially if they just have protected income and no other garnishable income. Even if there is a debtor's exam court order, helps can't go with the debtor or change the outcome. So I appreciate your channel advice, but what is helps doing that a senior who can read and write not do for themselves? Sincere question. I hope to hear back from you. Thank you, Ed. And that is a sincere question. So I'm going to read you my answer. And I say, sure, some seniors can deal with these problems without our help. And to this I say, great. But to answer your question first, it is not necessary to send a cease and desist letter by certified mail. Okay, you don't have to send it by certified mail. Anyway, a senior or person can send a cease and desist letter to a debt collector. In fact, we have the forms on our website. Some seniors choose to do it themselves. However, it is a fact that the vast majority of seniors are uncomfortable with dealing with debt collectors themselves for many reasons. Some debt collectors don't respect a cease and desist letter that comes directly from a debtor. It is different when it comes from an attorney. The collector knows then that the debtor is represented by an attorney and they know their rights. They have to go through the attorney then. Otherwise they get sued and they could cost them money. So many elderly seniors, because of age and circumstances, are not in the position to send multiple letters to multiple creditors and debt collectors, often over years. Then what when they get a new collection notice from a new debt collector? Then what if they are sued and receive a summons and complaint with a date and time for a court appearance? Do they know what to do? Do they understand the court process and that they don't actually need to go to court? Do they know what to do if they get a default judgment and and a request for additional information based on state law? What if they have a question about past due income taxes they owe, or if they have an RV or car that needs to go back, or if they're worried about equity in a home and laws protecting assets if there is a judgment? The difference between a bank and a credit union. You mentioned a debtor's exam. Very few helps clients who are sued are even served with the debtor's exam. Why? Maybe because the creditor knows that the debtor has an attorney and that knows their rights, and it would be a waste of time. Or the fact that on those rare occasions where a help client received a debtor's exam, helps contacts the attorney and provides information indicating that the debtor's appearance would be unnecessary and the exam is canceled. Okay? Debt collectors are famous for taking advantage of senior debtors who don't know their rights. A debt collector doesn't have to tell a senior their rights. If a senior can be scared to call them, then arrangements for payments are made. Payments for a debt that doesn't need to be made. Collectors are under no obligation to advise a senior of their rights. Some helps clients even cancel our service, but a significant percentage of those clients call us back and re-enroll because they can't deal with the harassment when the harassment starts up again. While our main mission is to stop collector harassment, our second mission, equally important, is to provide ongoing education to struggling seniors about their financial rights so they don't need to worry. But you're right, some seniors can handle these matters themselves, and there's nothing wrong with that. And that's what I put as an answer earlier today. And then before Helps YouTube Live, I got a couple calls that were put through to me from existing clients, one of whom was served, the other one had questions about, and I said to myself, this is a perfect example why, seniors can't handle this. The vast majority of seniors can't handle this stuff on their own. They worry about these kind of things, and that's what helps us here, to stop you from worrying. So yeah, if you want to do it yourself, you can. But if I had 50 seniors in the room, 49 out of 50 wouldn't want to deal with it on their own. But once in a while, you might get some old codger that really is and that's fine. That's great, and that's what maybe this person is. They want to deal with, and that's great if you want to deal with it on your own. I don't mind. We're plenty busy. There's 40 million seniors have incomes within 200% of the poverty line. They're classified as economically vulnerable. Helps has tens of thousands of clients, but we should really have millions of clients because there's millions of seniors out there with these financial problems that don't know what to do. So yeah, if you can handle it on your own, that's great. You don't need us. But a lot of them need us. That's why. So if I were telling people how to deal with it on their own, all day long we'd be getting calls. What do I do with this? What do we do with that? No, that's what we do. Okay. So I'm worried they will go after my car loan or my checking account. I plan on switching. Okay, that's fine. They can't go after your car and they can't go after your checking account if it's a bank, unless it's Truist Bank. But some people just feel uncomfortable with not paying a credit card with a bank where they bank, and they'd feel more comfortable choosing going to a different bank, and I understand that. Okay, Eric, stop giving that troll so much attention. Oh, I didn't think of it as being as a troll. I'm sorry, but it's a good question. He wants to know, and I answered it. Okay. Um, yeah, Kathy, I don't know who wrote that because it's a lot of work that helps does, and it's not just one time cease and desist as well as outcome when you get judgment. I choose helps over anything. Yeah, I know that. I understand that. That's why, and I've dealt with this over the years. People say, "Well, I can do this myself." I said, "Well, yeah, sure you can. Go and do it." But I deal with seniors. I know what it's like because I deal with it's. I deal with a lot of seniors. They don't have they may have an iPhone, but they don't have a printer. They don't know how to write things, and they don't want to have to deal with their phone call. I mean, it could go on and on. I've called help so many times, and they're always there. Why stress when you have helps to vent to? Okay, Jim says he is trolling. Yeah, I guess I'm an innocent in some ways. Maybe he is. I don't know. Okay, I got to remember. I got to end in about 7 minutes, folks. We're going to be short today, but we'll have a full session tomorrow. Here's a little note. I have. I'm 66 years old and worked until last year and received Social Security and pension. I took out a loan from Net Credit about 3 years ago. I'm now not able to make all my credit card payments. I've contacted some of the credit card companies and some are working with me. However, Net Credit refuses and I am getting where I cannot afford to make the payments. How much does it cost for me to? I think May already answered this, but no, we don't turn. Okay. Can you explain the power of attorney for married couples? Are they needed? That's a pretty interesting question. Should a married couple get a power of attorney? Um, and I think I answered this. This was a comment on maybe one of the YouTube videos. I said, it might not be a bad idea. Normally, if you had a joint bank account, if something happened to your spouse, then if you had a joint bank account, then you could handle the bank account. But if it wasn't a joint bank account and your wife had or husband had a separate account and they became incapacitated or passed away, then it could be a headache if it was just in their name. And a lot of couples, they own their home together, so if the spouse passes away, then they can deal with it. Um, the home will automatically go to the surviving spouse. But let's say the spouse got a stroke and was incapacitated and it was owned to them jointly. Yeah, I could see where a power of attorney would be really handy to have so that you could, deal with a home loan or selling the home or something if your wife or husband who was incapacitated couldn't sign paperwork. Um, Same thing with a car. Maybe you own a car together jointly with survivorships, right? But you might own titles in separate names. So it could make sense for you to have a power of attorney from your spouse. Okay? You've been married for a long time. You trust each other. Nothing wrong with that. Okay. Glenn asks, any idea how I can get a car now that my credit is ruined by not paying? We have an email that we'll send to our clients called Affordable Transportation. Okay? So I've been dealing with this ever since help started. Clients would call on the phone and they'd say they might have a car they couldn't afford anymore and it needed to go back. But they needed a car. And I used to tell people, I said, and I still have a video that talks about that. Get on Craigslist, owner only, runs good, or Facebook Marketplace. And I used to tell people, for $1,000 you could get a pretty good car. It might be a little bit more now, but if you look on Craigslist under owner only, runs good, a person that's selling their own car isn't going to tell you that it runs good unless it does run good. They don't want you calling them next week saying you lied to me. Now, a dealer that sells you a used car, it's always sold as is. They don't have any promises that go with that car. And usually you can get a better buy, cheaper car directly from a private party. And, it's not a car that you're going to be driving across country, maybe the doctor and back. But if you got a $400 car payment, in 3 months, that's $1,200. If you stop making your car payment, you might be able to hang on to it for 3 or 4 months before it was repossessed. You'll be able to save enough money and be able to get a car. And then also, there's Uber and there's Lyft. It's often possible to get a pretty decent car for under $2,000. Okay. It may not be a perfect car, but it doesn't need to be perfect. And then the advantage then is that if you don't have a car payment, you only have to pay liability insurance. You don't have collision and comprehensive. Your insurance bill is going to be a lot less. So, yeah, you can get cars. You might have to save up for a little while. Okay. Okay. It looks like it is almost 40 minutes. We've been on Helps YouTube Live. I got to go to this meeting. I want to thank you for participating today. These are some good questions. If you have any questions, contact us. 855-435-7787 helps us or helps US. We want to answer your questions. We want to be able to help you. We got paralegals that can answer your questions now. You don't need to be scared about calling us. Sometimes people say, I've been really worried or scared of calling you. And they're always relieved when they talk to us. So I'll talk to you tomorrow and have a great day. God bless. See you later.